321.
Продовжуємо засідання.
Let us resume the hearing. Please, the Secretary would bring the candidate for the position of the Hague Judge Odariuk Mykhailo through a video conference link. Please let us know that the candidate can hear us, can see us, and the connection is working fine. Good day. I hope you can hear me. Can you see us and hear us? Yes, greetings from the United States of America. I'm sorry for joining you through a video link. Fine, good day. Let me announce that we are hearing the compliance of the candidate for the position of the Hague Judge Odariuk Mykhailo with the Part 4, the Article 8 of the law on the Hague. We have the following international experts: Gabriele Yudkaisa, Norma As, Robert Bronzheisa, Jessica Thompson, John Hyla, Людмила Волкова, Євсан Васильєв, Роман Кадисюк, Олег Павлюш, Володимир Воланський, Руслан Мельник, Василь Милян, Андрій Пасічник, Роман Сабадаш, Руслан Здорович, Сергій Чумак, and Галина Шевчук. You have the right to file recusal to the members of the Commission under the legal grounds. File recusals, file motions, provide explanation with the Chairman's permission, voice your opinions, objections, and file complaints under the law. This joint session will not consider any new materials submitted by the candidate if the opportunity was provided such the materials if the candidate or other individuals had not provided it to the PCIE or the Commission, and on the initiative of the candidate and 3 members of the PCIE and the Commission and the joint decision can make to admit additional materials. At least 3 members of the PCIE had voted for the decision. Would you like to recuse any members of the Commission? No, I do not have any recusals. Do you have any motions? I don't have any motions at this point. Thank you. The rapporteur is Serhiy Chumak, the member of the Commission. Over to you. If I may brief, Odariuk Mykhailo was appointed to the position of the judge of Izum Court in Kharkiv region by the decree of the President of the 3rd of December 2019. The decision of the head of the Supreme Court of 25, he was commissioned to Irpin Court to administer justice from the 5th of June 22 and 11th July. The decree of the President had enrolled him in the staff of the court. Further, I would like to inform you that Mykhailo Pavlovich held an administrative position and is still holding an administrative position, was the president of Izum Court in the years 2017-2018, and is currently holding the position of the deputy president of Irpin Court since April 23 for the tenure of 3 years. He was a delegate in 2014 for the 12th convocation of judges of Ukraine, the High Council of Justice of Ukraine. As of 15th of January 25, it made 7 candidates for the positions of the Hague who have successfully completed the qualification, in particular Odariuk Mykhailo for the second round of qualification changes, and the interviews as of 23rd of November 2023 under this number with the changes. The briefing is complete. We may proceed. Mr. Norman, over to you.
Thank you.
Robert, over to you.
Yes, thank you, Mr. Chairman. This case will be handled by my dear colleague, Norman. Please go ahead, Norman.
Thank you, Robert. Good afternoon, Mr. Odariuk.
Good afternoon.
Yes, I'm your rapporteur, and I'm very delighted that you have participated in this competition and also for your availability for this interview. We have had already several written question and answer rounds, and many questions are answered, but there are some issues what you I like dig deeper in. And as we should keep in mind our time schedule, and we like to end approximately 6 o'clock or a bit later, I would ask, or I would please keep your answers as short and precise and to that point as possible. And please do not exceed 3 minutes per answer if possible. May I start with my interview with the questions? Actually, I'm just interested. What is the legal basis for your stay United States at the moment during the martial law? I have understood that you need a special approval or consent to leave the country during the martial law.
Так, добрий день ще раз усім.
Good day, everyone. Once again, I would like to welcome the High Qualification Commission of Judges, the Public Council of International Experts members, and before I answer this question, I would like to note that I do understand the question, but I only keep hearing it in English. So far, everything is clear. The question and the introductory part of the interview, but should I have any difficulties with understanding English, if you could offer the interpreter who'd be able to interpret the relevant part of the sentences or the questions posed by the international experts. Mykhailo, we have simultaneous interpretation provided. I will ask the secretary. I see the message. You may need to set the right Zoom channel.
Одну секундочку.
If you would allow me a minute.
Додатково переклад. Ага, є. Так, все. Все, да, чутно. Дякую.
Everything is working. The interpretation is working. I forgot this function. I'm sorry.
Як я правильно розумів, питання стосувалося того,
if I understood you correctly, the question was the purpose and the grounds considering the limitations on public service, including the judges, for going to other countries, including the United States of America. Is my understanding correct of your question, Mr. Norman?
Yes, my question was, what is the legal ground leaving Ukraine during the martial law? Yes.
Так, зрозумів. Річ в тому, що я був
ще The thing is that in July 24, I was nominated by the USAID program as a member in an event called International Visitors Members Program. This is a program funded by the Department of State of the United States of America with the support of the American Embassy. Unfortunately, the date and time when I was informed of the special hearing coincided with my stay in the US. Therefore, I could only attend through a video conference link, and the document entitling me to leave the country is the decree of the President of the Court sending me on a business trip to the United States, to the city of Washington. Thank you.
Thank you. And are you there with your family or alone?
Програма IVLP забороняє.
The program IVLP forbids the participation of members of the family. They are located in the city of Kyiv. And I'm actively monitoring the notifications of missile and drone attacks. It might seem fine, but it's unnerving me.
Thank you. Now, to the issues. Since 2013, you have been a judge of the Iziumi City District Court. It's correct?
Так,
And where
This is so.
where did you live from 2013 to 2019 when you were a judge in this court?
я проживав в місті Харкові.
I
За
lived in
своєю адресою
Kharkiv
там
at my
зазначено
address
з 2008
as
року.
stated since
Якщо можна, я не
2008.
буду її називати
I will not name it with your
для
permission
заходів безпеки.
for security
Там я
reasons.
проживав весь цей час.
And I had been living there all
Я
this
їздив
while,
на
and
роботу,
I traveled
так,
to work
повертався.
and
Як вам
went
відомо,
back.
думаю, що ви знаєте про це,
I
то
think you
в
will
2014
know that in
році
2014
не був приведений до присяги.
I
Присягу
wasn't given the opportunity to take the oath. I was given a chance to take the oath of 31st of March of 2015. So I had a free schedule since I could not administer justice. So I dealt with some general matters as requested by the president of the court. I handled transportation of the cases to make myself useful in this interim periods of since 2015, before I started declaring my place of state. I traveled with my colleague. I used the BlaBlaCar service, and I also used the suburban trains because at home I had a small child, my first child. He was 3 years of age, and I was keen to spend more time with them, even for shorter time when you arrive in the evening, but still it was preferable to stay in the city of Izium. Thank you.
How far was your home from the court, and how long take this commuting to work and back home every work day?
Відстань 120 кілометрів в одну сторону.
The distance is 120 kilometers one way. So by car, it would take an hour and a half, and by suburban train, it took almost 3 hours. That's it. Thank you.
So, understood I correctly that when you used the train, it took almost 6 hours to your workplace and back to home?
Так, але іноді
Yes.
я назад їхав.
Sometimes I hitched a ride back. I asked colleagues to give me a ride, so it didn't take that long.
And can you explain usually how many days you during the business week you went to Izumi? Every day or just a couple of days during the week?
Ні, безумовно, щодня в мене робочий день
Surely,
з 8 години.
my working day is from 8 to 5. I couldn't fail to arrive for work, turn up for work, and that would be prohibited. I wouldn't be counted a full working day, but just the number of hours when I was physically present. Surely every day I commuted.
Do you have also used your personal car for that during those years?
Я міг використовувати
I
і
could
автомобіль
use
дружини,
my wife's vehicle and so-called blah blah cars. It was a very common service, and you could hitch a ride for a cheaper price, which was better than driving myself. So further in future, and I stated the year when I could make use, and I did make use of the vehicle that I had sold, and I did use the vehicle to commute to work. That is true.
You mentioned that you also used your wife's car. Is that correct?
Безумовно, це машина дружини.
Surely it's my wife's car, it's our family vehicle. She is the owner, and I could take it and use it. It's our shared asset.
Of course. I was just wondering how often you used your wife's car or your family car then. Every week or?
Depending on the circumstances, if my wife needed a car, she would drive it. In my case, I felt that the preference should be given to my wife who had a baby, then had to ask my parents to give her a ride, but could be more autonomous. When she did not need a car, I could use hers.
Can you remember how often you used, for example, a train to go to Izumi and back? It's every week again, or it was quite rare? Because as I understood, it took together almost 6 hours.
This was not rare. All those means of getting to the workplace continuously changed because I opted for the solution that was more comfortable, that could let me get to work faster and get from work to home faster after the end of my working day. So if I could not find a car, if I could not take the car, I would go by the train.
And this public transportation, this train, it started before your working hours. Reach Izumi before the working day or working hours. You mentioned that the usual working day started 9 o'clock. Okay. So it was possible to go with train and arrive before 9.
My working day started in more remote courts 8 to 5, so it's an hour earlier than the standard court time, considering the nature of other parties, the litigants. So I did arrive. There were a number of subway trains and their scheduled changes. I usually made it, but I made it in time, let's say 30 minutes past 8, up to 8:30. The railway station is located in the vicinity of the court, and I could make it in 5 minutes from the railway station because the city of Izum is a small one.
Thank you. And the last question in this issue, you mentioned in your declarations that from 2019 you had opportunity to use some apartment in Izumi. Can you comment that?
Yes, the thing is that in 2019, I think, or 2020, as the declaration says, in that period, I was really tired. It became quite a burden to get to Izum and then back home. And we decided, and at that time our older child was already 9 years old, and she could help my wife with the younger child, so my participation was not so much needed. That's why I asked my father, I asked him whether he knew anybody who could give me some premises to rent, to pay for it, or for free, because in the town of Izum, that's a small town, and there's a big problem there to find some good accommodation, at least a one-room apartment, so one could live there in a comfortable way. He found such a man. I met him. He worked for the State Service of Emergency Situations, and my father had worked within that system for more than 30 years. And so he could find such a man. It was the apartment owned by this man's mother. And we agreed. He said, okay, no problem. You can use it any way you want, no problem. At that time, it was not in a very good state. So I did some renovation work there. I put, a bathtub in it and a fridge that I bought. And that was that. But as to the rest, it was just, I used it for free.
Okay. And can you remember how often you use this apartment? Again, once a week, twice a week?
No, I would use it at least 4 times. Well, I would spend 3 nights there because I would come there on Monday, and then Friday I would leave it. And that means that Friday, Saturday, and Sunday I spent at home. So that means 4 nights that I would stay in that apartment. Let's say if that was just a usual working day, unless I was, taking a training somewhere. At that time, we still had offline training sessions, and sometimes there would be other business trips. So it was not like every week was not exactly the same thing every week.
Yeah, thank you. Another topics. I have one question about your apartment in Kharkiv. You have declared that since 2010 you have owned an apartment in Kharkiv worth 71,000 Ukrainian hryvnias. And you also said that from that price, 60,000 hryvnias was provided by your mother. Is it correct?
Right. Yes, I said that during the qualification assessment. I provided all my comments about that. Nothing has changed.
Okay. According to your declarations for 2016 until 2022, your mother periodically gave you significant gifts. For example, 2016, 145 hryvnias, 2017, 150,000 hryvnias, the same amount next year. I have a question. Were these gifts done in cash or as a bank transfer?
Ні, вони надавалися готівкою.
They were done in cash, in several installments, several amounts. This was not just one amount. I understand it's a relevant question. I did not even understand first what the question was. Why? Because at that time it should have been declared because it meant changes in my asset status, but she would give me 20,000 hryvnias, sometimes 3,000, 30,000, 4 or 5 times a year. So it was not to be declared. But I still openly declared those amounts every year. We would count them up and I would put them into the declaration, because although I may have not done it, but I thought it would not be correct, and if I received this money, it was my duty to declare it.
Thank you. According to your declaration for 2019, you received a gift from your brother. The amount was 480,000 hryvnias, approximately $20,000 according to the rate this particular year. Again, the same question: was this gift done in cash or as a bank transfer?
Так, відповідаю. Це було також зроблено
It
готівкою.
was also done in cash.
Я надавав вам документи, які
I even provided the documents to you that show that my brother owned a cafeteria in downtown Kharkiv, which was quite a valuable facility, and my parents and my brother decided that we would share that amount of money, and the decision was made that that was the amount of money I would receive, 480,000 hryvnias.
Have you ever made such monetary gifts to your relatives as well? Comparable amounts?
Відповідаю. Напевно, про це треба було сказати на
Well, I should have said that before, probably at the very beginning, when you started asking the questions about the assets and the property. The thing is that before I graduated from the National Legal Academy, then it became the National Legal University, named after Yaroslav the Wise. My parents, and I agreed with them completely, they decided that in order for me not to think about some material pecuniary problems, they would give me money so I could deposit them in a bank and receive interest, to feel comfortable and not to think about tomorrow. All the other things that happened after that, gifts from my mother and from my brother, all of that was done within the context of this kind of a conversation that we had. So I could study, so I could only work on my career, first at the commercial court as an assistant first, and then as a judge, so I would administer justice without thinking about, well, not having enough money to buy something.
Thank you. Yes, in your declarations and also in the written answers, you explained that those origin of those funds were mainly your mother and your family. But could you explain when you made this deposit first, in which year? You were in the university, I understood, but can you remember the year?
Так.
Yes. I provided you with such documents on purpose during my qualification assessment as well, which in fact shows the periods when the money was put on the deposit, because those deposit contracts were restricted in time. They were usually yearly contracts, and I would deposit them, in various banks where the rates were better, where their interest was better. I would choose the best option. And the first interest that I received that in 2007, 2008, when I didn't have any positions at all. I had just graduated from the National Law Academy, I received my diploma, and I had to start working at the Administrative Court of Kharkiv region because as a person who had studied with support of the government, it was my obligation to work for several years to pay back for the budget allocations.
Can you remember the sum what was initially put in the bank as a deposit? Amount, total amount.
Да, безумовно, помню, це було
By all means, I do remember it.
50 тисяч
It
доларів.
was $50,000, 50,000 euros, and then $50,000 more. Then it was 50,000 euros. We decided that the interest for the euro deposits were very low compared to the US dollars. And when the contract expired, I took the money back and I gave it back to my parents because it was not my money.
Okay, but understood I correctly that there was 2 times $50,000 and 1 time 50,000 euros, altogether almost $150,000.
Майже так.
Well,
майже
yes,
так.
almost. So
А потім вони ж були переконвертовані в гривню.
then it was converted into Ukrainian hryvnia because that was mandatory, and that amount of money, well, it did not change much. I didn't take the money back.
Can you remember, were you saving only in one bank or in different banks?
Майже всі
Almost all those savings were at the Privat Bank. That at that time was private bank. Now it's a government-owned bank. 1 year I took the money away because deposit conditions were better in another bank, VTB Bank, and I had a deposit contract or agreement with them. And after that deposit agreement expired, because we all know what VTB Bank was, that it was a government bank of the aggressor country, and I categorically didn't want, although they proposed very good interest rate for my deposit, but I said, no, I would better put them back into Privat Bank and would get less interest rather than keep them in the VTB bank accounts. That was my position of principle, although their interest proposal was better.
Just for clarification, can you remember in which year you withdraw this deposit from VTB Bank?
Якщо ви мені дасте ровно
Well,
30
if you
секунд,
give me 30 seconds, I will find the certificate and I will tell you what year it was. I also provided that document during the qualification assessments that can be found in my file. If you give me 30 seconds, I'll tell you.
Так, довідка, що за період з
The certificate confirming that in the period between the 1st of January 2013 and the 31st of December 2013, at that time I had a deposit at the VTB Bank.
Thank you. In your declaration in 2013, you declared first time that your wife has a deposit worth of $50,000 US. This was the first year. Can you explain from what is the source of that funds?
Так, пояснюю, що моя дружина, ми з нею
My
одружилися в
wife,
кінці
we were married
липня
in
2008 року.
July of 2008.
Почали проживати разом в
We started living
наприкінці
together
2007 року.
in late
Це
2007.
були кошти, яка вона або
This was the
самостійно
money
заробила,
that
а
she had
також
either earned
її
by
мати
herself
та
and
брат,
also
оскільки
her mother
батько
and her
вона
brother,
з батьком там
because
дуже давно мати
her
розійшлася і
mother was
розвелася,
divorced
то
from her father
тільки
a long
мати і
time
брат. У них
before
був
that, so she just had a
павільйон
mother
на
and a brother, and
ринку
they
в місті
had
Харкові,
a
на самому
market
великому ринку міста Харкова.
place at the biggest
Відповідно, вони там заробляли
market
гроші,
of
оскільки
Kharkiv.
вони мені
They
пояснювали.
earned
І
some money there,
коли
as far as they could
я, в
explain it
принципі,
to me.
розповідав, що
And
є
when
така
I
процедура, що можна покласти
told
гроші
them
на рахунок,
about
вони
such
про
a
це не знали,
procedure of
що якщо
depositing
ви
money with the bank,
бажаєте,
they
значить
didn't know
все
about
в
that.
порядку,
And I
ніяких
told them, if you want to do
кошти не
that, then
зникають,
the money would not
тому вони
disappear.
вирішили
That's why they
також це
decided
зробити і для того, щоб
also to
її
do that
донька і сестра
for
мали певну
her daughter and
фінансову
sister
подушку.
to have some kind of a financial cushion, as they
На
say.
превеликий жаль,
Unfortunately,
як я це також зазначав в межах
and I
кваліфікаційного оцінювання,
also
і зараз
noted
підтверджую,
that during the qualification assessment,
мати
and I can confirm
моєї
that
дружини, вона навіть
that
не знає,
my
що в нас
wife's
є
mother,
ще
she
один
doesn't even know
тому
that
що
she has
вона
one more
не спілкується з
grandchild,
нами з того моменту, як
because she
старшому
hasn't
сину
been talking to
було
us since the
3
time
чи 4 роки,
when
і
our
потім ні
older
на який
child was
контакт
3
не
or
виходимо,
4,
навіть не
and
знаємо,
then
чи живі
she
вони,
didn't
чи
have any contact
це
with
ні,
us. We
незважаючи
don't even
на
know whether
військове
she is
село.
alive because of the military aggression.
Thank you. And one more question on this issue. When I compare your declarations 2012 and 2013, the deposit in the bank or the funds increased significantly more than 2 times. What is the reason for that? You explained during written round of question and answer that it was the changes of the rate between the hryvnias and the US dollars, but it's too high for me, or can you explain?
Ну, українці знають, про які обставини,
Well,
про які
Ukrainians know what
що сталося наприкінці
was the situation in late
2013 року,
2013,
і що стався Євромайдан, і відповідно
and that
курс
we had the Euromaidan, and therefore the rate increased almost 2 times,
зважаючи на це,
the exchange rate.
жодних коштів я нових не
I
вкладав. Це
did
одна
not
і та ж
deposit
сама
any
сума. Вона
additional money. That was the same
просто вона
amount of
збільшилася
money.
в
It
гривні,
just
але
increased
в доларах
in
вона
the
була
Ukrainian
точно
currency,
та
but
ж
in
сама.
dollars it was exactly
Потім,
the
коли
same.
перевели в
Then,
гривні,
when it was converted
фактично, коли
into
це була, я не
hryvnias,
пам'ятаю, це була чи націоналізація
whether
Приватбанку, чи була
it
якась
was
реформа,
when the
зараз не можу
Privat
точно
Bank was
повідомити, я просто
nationalized or
пам'ятаю
whether
цей
it was
момент.
reformed, I
І
just remember
виявилося, що
that time
ці
it turned
50
out
тисяч
that
доларів, вони
those
були,
$50,000
в 30 тисяч доларів.
became $30,000, which was not very nice.
Thank you. Now, I'd like to have some questions about your wife's car. According to your declaration 2012, your wife owned a car Audi Q5. And in your judicial share, you gave an explanations that the respective car was purchased at the expense of my savings with my wife, as well as through the sale of a car purchased my brother. Can you remember what was your part or your funds in this purchase?
Чесно кажучи, ні, наскільки я
Well,
пам'ятаю.
frankly, I don't, because as far as I remember, I personally did not invest anything in the purchase of that automobile because there was enough money to buy the car then.
Okay, but can you remember what was the reason for your brother to give this money to your wife or to buy this car for your wife?
Я зрозумів. Це мається
Yes,
на
I
увазі,
understand.
що,
You
він
mean
надав,
that he
він надав автомобіль в
gave
трейд-ін,
us the car?
який
Oh,
у нього
he
був
used
власний.
his car, the car he owned, and
Цей
a
автомобіль, це
trade-in, and that was an
відповідно, воно
Infinity
було,
car, so
враховано, і залишок було
that
сплачено.
was taken into account, and the rest is what we paid.
What was the reason for your brother? This was my question, to give it this money. Was it a gift or?
Річ у тому, що ми,
The
в
thing
принципі,
is
всі рішення щодо майна,
that
якихось
all the
рухомого
property
майна,
decisions
нерухомого,
about
всі
real estate
питання
and
ми вирішуємо
movable
спільно,
property we all
як родина.
make
Це
together
мій рідний
as a
брат,
family. It's my
і
brother,
батьки,
next of kin,
було
and my
вирішено ось
parents.
так. Я,
So this is how
чесно
it was
кажучи, не пам'ятаю,
decided.
він купляв собі
Honestly, I
нову
don't
машину, не
remember
знаю.
the rationale.
Купив,
I know he was buying a new car, and
грошей
he
в
did
нього
buy
вистачало,
a
а
new
цю
car.
машину
He had
ми,
enough money,
відповідно,
and
передали
this car was
по системі трейд-ін.
traded
Тоді ще
in.
можна було так
At
зробити.
that time, you could still do that.
Okay, thank you. In 2018, according to the declarations, your wife sold this car with the price approximately $50,000 US. And how did your wife manage to sell the car for such a high price, almost the same car price as it was brand new car after 6 years of use?
Так, відповідаю. Це питання
And let
дійсно
me
воно
answer your
поставало.
question. This question was
По-перше,
raised
є документальне
earlier,
підтвердження
and
цього
there is
факту,
a
воно підписано двома
documentary
учасниками, і
confirmation and is
це
signed
зафіксовано
by
відповідно
two
судом.
parties, and the amount is
Я
recorded
не
there.
вона шукала
It wasn't her
покупця,
looking
це
for a
шукав
buyer.
я, і
I
ну,
was
це
looking
було
for a buyer,
відповідного
and
салону, в
I
якому ми
went
купляли цей
to the car
автомобіль, для того, щоб
dealership
у
where
них
we
була база
had bought the
клієнтів,
car initially because they
вони
had their
обслуговували
own
цю
client
машину,
base. They serviced
вони
the car.
знали, я, наскільки я
They
пам'ятаю, вони
knew,
надали
and
мені
I remember they were the
контакти,
ones
тобто
to
людина
give
сама
me
подзвонила,
the details. The person had initiated the call.
вона подивилася, машина
The
була,
person checked the car.
дружина і я їздили,
My wife
ну, там
and
був на
myself drove the
одиметрі,
car,
це було 25 тисяч
and we've
кілометрів.
just driven
Машина була
25,000
в
kilometers.
поліції,
As the kilometer meter said, it
спеціальній,
was
яка
still
захищає від
packed
будь-яких
in a
там сколів
special
і
sealing, protecting from any damage
покриття.
to the
Тому вона
surface,
була
to the
нова.
animal.
Всередині
So
вона
it
була
was new.
нова. Ніяких
Inside it
проблем
was
з
still
сидіннями,
new.
з
There were no
механізмами не
problems
було,
with the
тому що
seat, with the
фактично
mechanism, with the mechanics,
гаранта
because
того, що ця машина в
guarantee that
ідеальному
this
стані,
car is in
виступав
a
сам
perfect
салон,
condition was
який і
the
знайшов відповідного
insides of the
фактично
car,
покупця,
and this
надав нам
attracted
контакт.
the
Ну, ми
buyer
жодним чином через салон не
and the dealership
комунікували, а
of
просто вони
referred
надали
the
контакт, і
buyer. They
ми
just gave us the
домовлялися про
contacts
це.
and we arranged the deal.
Thank you. The last question was, this is the same car what you use sometimes to go to your court in Izumi?
Так, я іноді,
Yes,
да, звісно, ну
I
це
did, surely. I did.
Okay.
Yes.
The next question is about
Norman, if I may interfere, you are on the end of our time.
I know I have questions.
Yes, but at a certain moment we have to pass on.
I have a couple of questions about the next car, Audi Q7. You explained during the written round of question and answers that the source of the funds was a loan from the bank and also your own savings. Can you remember what was the sum what you loaned from the bank to buy this car?
Зараз, якщо можна,
If you would
30
allow me
знайду
30
цей
seconds
документ,
to look up the
якщо я не помиляюся,
document,
це було
and if I
400
remember
тисяч гривень,
correctly,
якщо я не
it was
помиляюся.
400,000 hryvnia, but let
Але
me check.
я також надавав ці документи.
I
Зараз
did
ось
submit the documents.
Так.
So a second.
400, так, 425 тисяч, так, 425 тисяч гривень.
So
Так.
it indeed was 425,000 hryvnia loan.
You explained during the previous round that actually your mother paid the loan. And I have the questions, how your mother paid this loan, directly to the bank, or she just gave you the money and you paid the loan to the bank?
Відповідно, оскільки я був учасником
Since
цих
I was the party to the loan, my mother could only do it if I had given her a power of attorney for such operations. I did not issue the power of attorney. I received the money and I paid them back immediately.
Okay, and how, in which form the mother gave you money, in cash or via bank transfer?
Готівкові кошти.
Cash funds.
You also explained that the year after you sold the car, your relative, but the buyer couldn't pay all the price. And understood there correctly that almost half of the selling price couldn't paid by your relative. Okay. When did it become clear that your relative or the buyer would not be able to pay the full price?
Це родич, це мій
It's a relative.
троюродний чи чотирьохюродний
It's
брат.
my cousin, third or fourth line.
Дмитро його звуть.
His name is Dmitro Kukuruza.
Відповідно, все йшло добре.
Everything was going well. The first two payments were paid by him. I declared them, and they were paid in installments. Then they had a problem, and I did state his place of work. He worked in IT, and he needed money to tackle the market, and he didn't have the money, although we still had a valid agreement between us, but the money wasn't mine, as a matter of fact. The money belonged to my mother. She is the one who provided the money as part of the loan. So we decided that he will offer the services to her, offer her IT services, and my mother co-owned a restaurant business with my brother in the downtown of Kharkiv, and a cafe which was sold later, as we had discussed, and a gift was also made. There were some non-residential buildings and some circumstances, so IT support was needed, and it was decided that let him provide the services and refrain from paying.
Which year it was? Can you remember?
Якщо ми говоримо, тобто
If
2014-2015,
we are speaking 2014, 2015, so in 2016 and 2017, so 2 more years when it was still valid, so 2016, 2017, and this was one of the grounds for me to make use of the car. And we also decided, since he can't pay the full price, let him provide the car for use. And in this connection, following these events, I didn't use it at the time of the reporting period or the required number of days, because I would drive this vehicle to my workplace. People could see me driving in downtown Kharkiv. So it was decided, I decided personally, and I think it was right to declare the use of this car.
Was any document signed regarding the to settle the debt or provision to IT services?
Ні, наскільки це він наш
No.
родич, то
He's a relative of ours. He's a distant relative, but still a
вони
relative.
самостійно вирішили питання
They
щодо
settled the matter between themselves about their relations in IT. Our agreement remained as it was, and I did not take any action as I felt that he hadn't repaid the money to me, so it was still a valid agreement.
I have to interfere now, and if you don't mind, we pass the floor to the HQCJ so they can have the questions. And if something is left afterwards, of course, they can be asked. The floor to you, Mr. Chairman.
Thank you. I'd like to give the floor to the rapporteur, Mr. Chumak. Sergey.
Пане Михайло, ще раз добрий день.
Mykhailo, good day to you. Once again, good day.
Без наручників. Дивіться, пан Норман.
I don't have the headphones, and Norman focused on your assets, whilst I would like to talk to you about professional ethics, because I have some moments that I would like to clear with you. We have asked you to provide the explanations for your deployment to Irpin District Court and not to the Izum Court of Kharkiv region. If I may explain the context, why the cases of Izum Court were changed for Pavlograd in Dnipropetrovsk region. The general rule is known to you that the judge follows the case. If the jurisdiction in a case changes, the judge follows it. This is the general rule. But you ended up in Irpin court. So we asked why, and you provided the following answer. And I will read briefly because it's important and it pertains to my question. Next question. I asked to be deployed to Kharkiv to administer justice at this demanding time, but I was denied. Following that, I found a phone in June 2022 of a Supreme Court officer who dealt with the matters, who told me that there is a vacancy in one of the courts in Kyiv region. I filed an application in July 22. I was sent to work in Irpin District Court of Kyiv region. Instead, the Commission has your application at its disposal to the President of the Supreme Court, and I will read it out with your permission. Let me elaborate that you're writing to the President of the Supreme. I cannot agree to be seconded to Pavlograd Court of Dnipropetrovsk, where the courts from Izum Court were submitted because it's located at a dangerous distance from Donetsk region, is continuously under shelling, and I'm living with my family, which can put them in immediate danger of their life and health, and also requested to be seconded to Kharkiv or Kyiv. Would you think that you were not sincere entirely when you answered the questions of the Commission, because you haven't said that you objected in your submission to the President of the Supreme Court to being seconded to Pavlograd, where the cases from Izum were transferred. There is a war in the country. Pavlograd court is still operating as a court. The judges are sitting there. Even now, there is about 70 or 80 kilometers to the front line, to the area of hostilities. Back then, it was far in the rear, and it's still in the rear. There are judges like yourselves working there, and they have family like yours. So would you please say, I don't quite understand this letter where you deny your transfer to Pavlograd. The judges up until recently operating in Donetsk, and their judges still there. So if you could elaborate on your position. So do you feel this position is right when there are judges working then and working now in Pavlograd? And if so, why didn't you put it in your answer to our question? Because this is what we wanted to hear from you, why you didn't make it to Pavlograd court. You kept you silent, but we know your application. And this is how we learned why you didn't make it to Pavlograd court, because you had objected to the transfer. I do understand your question. I do recognize. I don't remember entirely. It was a situation that was difficult morally, and I do admit that I had written this letter considering the danger and hits on Pavlograd, where some objects, some facilities are located, which I would not like to say in broadcast for this information not to be made use of. Therefore, because I knew the situation in the city of Kharkiv and the number of prisoners of war taken, and that at the time there were just 3 courts operating in Kharkiv, and not so many judges had remained, many had left. Indeed, Mikhailo, I'm sorry to interrupt you. We don't have that much time. If you would please give the specific answer. I'm not asking you about Kharkiv. I'm asking you about Pavlograd. So don't tell us about Kharkiv, please. The security situation made me make the decision. I did not want, and it wasn't mandatory at the time. So no one would force you to write an application to the court where the cases were transferred to for adjudication. Given the choice, I felt I wanted to opt for a different court and not the Pavlograd court. Thank you for your answer. I have received the answer. The next question is also an interesting one, and I will explain the context to everyone else. It pertains to you considering a civil case 367/22. This is a case, this is a file, this is a claim to the State Agency of Amelioration of Fisheries of Ukraine about finding a decree decision illegal. The circumstances was that the State Amelioration of Fisheries, as a stakeholder of fishing company, terminated their powers and made the decision to dismiss a person from the position of the director of the company.
The dispute was about the fact that canceling the decision of the agency on terminating the contract with the fishing company director and invalidating the decision of the company's shareholder on terminating the authority and dismissing the company director. The person complained and asked that that decision of the state agency be suspended on dismissing the person from the position, on stopping the agency order on terminating the contract with the fishing company director, and banning the state agency from making orders about contracting any other person to the position of the fishing company director, and banning any person to carry out any actions to change the name of that person registered in the British Virgin Islands. On the 19th of October 2022, you completely approved that complaint, and you agreed with what the plaintiff requested. 3 days later, your decision was made on canceling the request with one motivation. You said that the information that was contained in the request contained facts that were not factual. As a result, the court suggested that the request was to be quashed. My first question is, unfortunately, you did not go into details in that decision. I think it would be important for us to hear what information was contained in that request that was not factual, and how did you establish that? I understand the question. Mykhailo, why didn't you write in that decision? Because the decision was not very clear, its arguments. Yes, let me explain. After the decision was made on granting the request, we received a letter from the representative of the defendant where he named certain circumstances that caused me to have doubts about the integrity of the actions of the plaintiff. The defendant provided a number of documents and decisions confirming that for procedural reasons, one could not do that, as a result of which I opened up the internet, I read it, and I saw that there were some issues that required a more detailed study, and not with the documents that we had originally received, but with more documents, as a result of which I decided that I had to quash that request and to bring it back to the original state. Frankly, I still didn't understand what were the circumstances that not meet the facts. But for example, if it said that the person had not made any other complaint for the same reason. Okay, so you established that another complaint had been filed. Well, I found that there had been some other complaints, and I had to check what happened as a result to those other claims. One of them had been filed with a district administrative court, another with a commercial court. We had to check what happened to all of them. And that's why I decided I had to cancel that previous decision to find out all the circumstances. And if they wanted to, they could file another claim, and then we could review that once again. Fine. But a week later, in November, a new decision was made on granting that request, and it was exactly similar to the first request. So you granted it in the same way as you did it the first time. And with that decision, frankly, it was not very clear what had changed. Can you explain that? First of all,
Сторона позивача подала
when the
заяву про забезпечення позову,
plaintiff
я вирішив
submitted a new
провести судове
request,
засідання за участю
I decided
сторін.
to have a
Для того,
complete
щоб
court hearing with
передбачити
participation of the parties, so
засідання,
it would
де
not be
сам
some kind of a
суддя одноособово
secret
вирішує, а
meeting
щоб
where the
сторони
judge
мали
would decide it
можливість
by himself, but
надати
so that the
свої
parties could
пояснення і
provide
заперечення.
their arguments, their
Було
comments,
проведено судове
and
засідання
objections. We had a court hearing
з фіксацією.
where
Було
the arguments were documented. Originally, we also granted the request on getting evidence, and that evidence was quite significant for the further establishment of the jurisdiction as regards that dispute, and as a result of which, in the court hearing, while looking at their request, the representative of the defendant did not provide those documents and said that he would provide them at a later stage while they were very significant. And because of that, or the decision was made, I made that decision, and I rendered that decision. Fine. Next question. Tell me, please. That dispute, did you consider it a civil one, a commercial one, or administrative one? Yes, it's true that that was quite an interesting situation. I had never had such disputes before, where there is a company, it doesn't really matter of what kind of ownership, where the government, the state, was a shareholder. So originally I believed that if there was a company, that meant it would be civil jurisdiction. Besides, the district administrative court of the city of Kiev wrote to me directly saying that that was the jurisdiction for a civil court. That's why, frankly, before I received the documents that the court had requested, and I started looking at the practice, which said that if there is a situation where the state owns more than 50%, then it's a dispute that should be heard as part of the commercial jurisdiction. As soon as we found that, and you know how much time it took us to make that decision, there was slightly more than 1 month between the first and the second hearing, while in my case it was a little bit more than 1 week. I was very interested in understanding what the jurisdiction was in order to bring that case to completion. You had a question about why didn't I do that earlier than on the 17th? No, I never asked that question. No, I didn't ask you this question. Now you clearly understand that it was a commercial dispute, and at that time you thought it was a civil case because the administrative court of Kiev informed you about that. Yes, but the district court of Kiev is not a court of appeals for you. Yes, I remember that. With your, I understand from your decision that you believe that it was a dispute about reinstating a person. Yes, and you wrote that in your decision. Yes, right. Well, the disputes about reinstating persons, after 10 years of having worked as a judge, you had such cases before, right? No, not very much. You never had such cases before? All right, you never. No, not too many cases. All right. You quoted Article 149 of the Code of Civil Proceedings, which speaks about the grounds for granting the request. And there are several grounds for that in Article 149, but I understand you chose just one, and you referred to it in your decision because you did not quote Article 149 in full, but only as regards the narrow ground, and you believe that the failure to grant such a request can make it impossible for the court judgment to be enforced. Did you have any other cases related to reinstatement of the person where you did that by stopping the order of dismissing a person? No, I had never had such cases before in my work. Why did you decide here to take a different road than in all the other previous cases? You had never done that before about reinstating a person by stopping the order, the dismissal order. In order to understand the nature of the legal relations, in order not to have any negative consequences, I decided to do that in that format. Then the Court of Appeals said it was a procedural violation. Right, we will come to the Court of Appeals later. My question was simple. Why had you never used such remedies before? Well, here in a similar dispute, you decided to use that measure. It's kind of a very different approach. Why? I said I had not had such cases before. That was the first case of that type. Well, they were not of the same format. They would be, for example, related to reinstating a person at a position in the Zoom City Council. What's the difference where you reinstate the person? Whether at a council or at a factory. Well, there we didn't have to grant the request. Okay, my next question. Because in your decision, you didn't provide the comments. So what could significantly make the enforcement of the court judgment much more difficult if you canceled that previous order and you reinstated the person, as you would do in all the other cases? The person would take the court decision and would be reinstated, and the average pay would be paid to that person, for the period of time. What could interfere with such a decision? Well, the person said in his complaint that he had no access to remedies in order to get the documents that would show that the person had performed the contract properly and that were no grounds for early termination of that. And that was the reason why I decided to make such a decision. Wait, we're speaking about the impossibility of enforcing the future decision of the court about reinstatement. If the person didn't have any evidence, there is the institute of providing evidence, of granting requests. In other words, there is the possibility to order that the evidence be provided. These are different ways how a person can get evidence that would prove that the person performed one's professional duties properly. That's not about the enforcement of the future decision of the court. You're now talking about how to enforce the evidence, but this is enforcement of the request of the claim. Well, I realized that it was a mistake, and in order to explain it somehow, it was a procedural mistake, and I do agree that I made a mistake, but that was only once. It was a single case like that. I have two more questions. In your decision about granting the request, in the first one and the second one, you wrote, you understood the situation. You said that you have to establish, following the position of the Supreme Court, about whether there are some whether the claims are the same as the claims about granting the request, and you decided that they were not exactly the same. However, I've already said that the object of your dispute was canceling the decision of the company shareholder on terminating the authority and dismissing the director. And also about canceling the order to terminate the contract. These were the That's what the complaint, and the request that you granted was to stop the decision of the state agency on terminating the authority and dismissal, and second, on stopping the order to terminate the contract. But that was the same kind of a request. But you also write here that he asked to stop the order on terminate the contract. It was the same thing. Well, before I heard about that from Kyiv Court of Appeals, I thought that these were quite different grounds, namely stopping the action or canceling or quashing. Canceling is a final action, while suspending it for a certain period of time until the issue would be resolved. I understand your response. And my last question was still about the appeals. You know the case law of the Supreme Court. I cannot tell you for how many years the court has had that case law. For 7 or 8 years. There is a number of decisions of the Supreme Court saying that one cannot grant a request, in particular in the reinstatement cases, in such a way as stopping the dismissal order, because in fact that means granting the request without hearing it on the merits. Are you aware of such a position of the Supreme Court? No, I didn't know about that. I was not aware of that. Later, of course, I learned that, I recognized that it was a mistake, and I never did that any longer. Well, the Court of Appeals wrote to you about that, but I'm surprised that a person with 10 years of experience, you were not aware about that generally well-known position of the Supreme Court, that one cannot do such things in reinstatement cases. Well, I hadn't had many cases like that before, of this category of cases. Okay, then my last question. Tell me again, that's about your ethical principles, and there was a decisive step. For the first time you had such a complicated case. Usually judges with experience, with 10 years of experience, like the one you had, they would usually be very careful while treating such decisive actions, especially in such disputes where you were not even sure about the jurisdiction, whether it was correct or not. Why, in such a situation, you did what you did? You granted the request, which you later realized that it was not correct, but you did it in such a decisive way, rather than be so careful. First, finding out all the issues, what was the case law of the Supreme Court, how the Supreme Court would decide such issues as regards the jurisdiction, especially as the Court of Appeals, in fact, wrote to you that it was a corporate dispute. According to the content of the appeals, it was clear that it was a corporate dispute. So what forced you to be so decisive? Instead of first understanding what the jurisdiction was, or how the law should be applied, there were just 2 or 3 provisions of the law. Why were you so bold and so decisive, and would it not interfere with your work as a judge of the High Anti-Corruption Court? You would also have such cases that you had never encountered before there. Yes, I agree with you. The resolution of the Court of Appeals was made much, much later, after the proceedings were closed in that case. If you look up the dates, clearly a judge should be decisive and should take responsibility for the decisions one makes. I really made a mistake, but like with other cases, if I have a chance to become a judge of the High Anti-Corruption Court of Ukraine, definitely I will try to make well-balanced, legal, lawful, and fair decisions and judgments. Thank you. In other words, you've learned your lessons. Yes, I have. And I have one more question that is not related to that case, but also as regards the ethical standards. That's the case of appealing the resolution whereby you were held accountable, disciplinary accountability, case 561/22. Well, without, of course, disputing your right to turn to the court. You have the right to do that. Everything is all right with that, but a police inspector held you to account according to Article 122. You objected, right? Well, you violated traffic rules where you crossed a road crossing with a red light. Allow me to tell you what the situation was. It will take me just 1 minute. You turned to the court, and the first instance court, you objected. You said that you had not violated the traffic rules, and the first instance court believed you, and your request was granted. That resolution of the police was quashed. While at the appeals, the police provided video recordings, and the Court of Appeals quashed it and wrote that the violation of traffic rules was confirmed by the video recording. My question is simple. You as a judge, you clearly deceived the first instance court, because that was the video recording that proved that you had violated the traffic rules, while in the first instance court you insisted that you had not violated the rules, and the court believed you. But the Court of Appeal, something was wrong, and there the police showed the video recordings which confirmed it. You're not a simple citizen, you're a judge. So that's about the ethical norms. Did you intentionally lie? Let me explain that. When I was stopped by the police officer, he was very rude, frankly, and when I suggested that he give me the evidence, because it was green light and yellow light, and at the same time he said that he would not give me any evidence, he would not show me anything, and I was a violator, and they would now make a report. I said, all right, in that case, I suggest that you put it off, because that's what the law suggests, and give me a lawyer that we can have a look at the video. Because I said, give me the video recording, and I will have a look at that. And if I really crossed it with the yellow light on, it was in the city of Kiev, it was a new city for me, and I did not say that I was absolutely right. He refused, and he said that the residents of Kharkiv were not adequate citizens usually, and that really made me quite nervous, because at that time I could not really know whether I had violated that. And as soon as we saw the recording, and the Court of Appeals decided that I had violated the court, and I paid a fine. Well, if the Court of Appeals could have a look at the video recordings, you didn't look at the colors of the... well, I have no more questions. Thank you.
Romane, over to you. Good day. I have a few questions. The first pertains to the questions raised by Norman. You have explained many assets that you possess as gifts from your parents. So your parents started doing business, actually starting your appointment. So they started acquiring the assets in 2013. So is it a mere coincidence? I have provided the documents in a request for the PCIe going back to the year 2000 when my mother was registered as a private entrepreneur, and the documents show that she has actively been doing business with my father going back to the early 2000. Thank you. And one more question pertaining to the measures of supporting the claim. There was a disciplinary claim in your name that you had seized some assets on the 16th of 9, right before the sowing campaign. So would the arrest on the sowing assets is harmful because this preempted the future harvest? This was within a criminal case. I'm not asking whether it's criminal. I'm asking you about the risks that may be there if you impose an arrest on the assets. The ruling ruled for the ability investigator to collect the harvest and transfer it for the preservation in custody. The investigator must have the tilling machine, and how was he to harvest? The investigator would bring in the state enforcement service, they would conclude the contracts. Why not let the person collect the harvest and then seize the harvested produce? That would be the instrumentality of the crime, but it's in the field. So would you just leave the harvest in the fields? It was a motion submitted by the prosecutor requesting the seizure of the property, and he provided the evidence proving that the individual would have harvested. And if you consider the number of hectares where the produce was sieved, and how would we ensure the preservation of evidence if the produce was harvested? What was the material evidence in this case? I didn't quite hear the question. You were saying to preserve the evidence, the material evidence. What was the key evidence in this case? In this case, the key material evidence was the harvest, because according to the wording of the motion, the individuals did not have the legal rights to make use of an extensive field where they had planted the crops. Following that, if they had harvested them, it would be the proceeds of the crime, and this is the evidence in the case. The number, how to assess the damage imposed on the government, because the other party, the other litigant in the case, was a state-owned enterprise. And the last question, going back to Fish and Company case, you had prohibited anyone from making any changes to the director, and the justification refers to the law on state registration. In your answers, you refer to the law of registration of companies and individual entrepreneurs. How does it refer to running a company from British Virgin Islands? I felt it could be impactful because the registration was also incorporation was done in Ukraine. If the company is incorporated abroad, how can the Ukrainian register contain the data about the change of the director of a foreign entity? I agree, it was a mistake. One more mistake. Okay, thank you. I have no further questions. Colleagues, do we have further questions? Please, over to you. I'm Ruslan Sidorovich, a member of the Commission. Mykhailo, I have a few questions I would like to pose to you. I'm not entirely clear. I would just like to elucidate it for my own benefit and perhaps for my colleagues too. When Mr. Norman was asking you about the deposits that your parents had given to you, that you had documented in your name, that had withdrew, converted, transferred, one point is not clear to me. You stated something about the mandatory conversion of currency deposits into hryvnia. If you would explain, perhaps you were not entirely precise. So what mandatory conversion did you have in mind? If I remember correctly, it was part of the nationalizing the private bank, or there was a relevant law under which all the deposits held in foreign currency had to be converted into a hryvnia equivalent. I do understand that was a law to overcome crisis in banking connected to the private bank. Thank you. Thank you for explaining. Fine. And I have another question. Look, your questionnaire states that you have a degree of PhD in law, which you had acquired in 2019, but you don't have an academic title. Your thesis is on land law. If you would please explain what triggered your interest in this topic and what is your academic paper about, considering that I started my studies in 2011. At the time, I was assistant judge in an economic court in Kharkiv, and we heard land disputes when I was appointed to the Izum court, and Izum court mostly deals with the land disputes, certain procedures between the farmers, between the land tenants. So I felt that, firstly, I will be able to tap on the relevant case law of my court or the cases I was personally sitting on. I do understand, Mykhailo, so the last question in this regard. Once you obtained the candidate of legal science status, why did you stop pursuing your academic endeavors? Why didn't you teach? Why didn't you continue writing articles? Did you lose interest in legal science? I am willing to continue my endeavors and keep writing, but for lack of time and because in any case, administering justice is a priority over any other rights and opportunities, including my right to teach. And I could only teach in Kharkiv, but not in Izum. It's very hard to make happen. So at the time, in 2022, you've been working for Irpin, and there are many legal colleges in Kyiv. This is what I wanted to say, that as of now, I've delivered 4 lectures in the State Tax University in Irpin, and I'm planning to, if it's possible, I was going through the selection procedures and I had lack of time. So I was planning. Thank you. It's clear to me now. Thank you. To continue on this question, a member of the committee, Melnik, you've stated that starting 2022, you've taught at the Tax University. Have you worked with the National School of Judges? Have you proposed yourself as present at the National School of Judges, consider your judicial record that could benefit the judges? Your question is clear. We all know the developments in Irpin, Bucha, Hostomel, the atrocity crimes committed there. The judicial dossier will show that I participated actively in the activities connected to the war crime cases, and I've always proposed myself as a lecturer in the National School of Judges on the topic, because now it is extremely relevant and the European Court is handling over 50 such cases. I have experience to share. Thank you. Thank you for your responses. Esteemed members of the Public Council of International Experts, do you have any further questions?
Yes, we do, Mr. Chairman. Norman, we had a few rest questions.
Yes, thank you. And I'm very sorry we are long over the schedules. But anyhow, I have a couple of follow-up questions about your dissertation already mentioned during previous questions. When preparing for this interview, we checked your dissertation with help of anti-plagiarism software, and it appears that in your dissertations there are many fragments and almost pages or many pages which are quite identical to some other previous textbook and dissertations, but there is no real references or real quotations made in your dissertations to those earlier works. And we also send you several examples about that, how you can comment it.
Yes, I have read the table that you had provided to me in your question very carefully. Most of it pertains to the definitions, legal definitions that could not be changed as it is the legal and academic terminology. Therefore, where it states that the impression can be made that only the last paragraph pertains, I did consider this comment, and if this is the impression that it creates, that I need to address it, get rid of this, and in the next thesis I will make sure. As for my author summary, when I started writing it, I found this to be a very demanding and hard assignment. At first, it's very hard to see and know, and I did seek the support of my scientific supervisor, asking him to provide some examples to use as a reference and to know what's expected of me in my summary. And if there is some semblance, it's there because it's about the terminology, and I had paraphrased, I provided my own text. So I don't think there are many such questions that would show that this paper has a plagiarism. It was checked for a plagiarism, and if it didn't pass this check, I would not be admitted for the defense of my thesis.
Thank you. And the very last question, did your salary as a judge increase after defending your dissertation?
Of course, yes, we have the right to 10% increase for the relevant status.
Thank you. No more questions. Thank you.
Thank you, Norman. I only have one remark, and I would ask the candidate to reflect on that when he is having his last word, because over time, and there have been many questions towards the candidate about gifts that were given, cars that were presented, issues with judgments that were delivered. We have heard that there was an issue with a criminal behavior of the defendant in a traffic violation. We have heard that there is something with plagiarism. And on our side, we are here as PCIe to make sure that that a judge in the high anti-corruption course has no issues regarding integrity, and it is clear that he has professional competence. However, after hearing all those issues, I'm quite sure if I look at my colleagues, we have issues to consider whether you indeed are in compliance with the rules and regulations of the High Anti-Corruption Court. So maybe if you can address those in your last word.
Я хочу сказати, що
I would like to say
безумовно
that without
є
doubt,
обставини,
the
які
circumstances
мали місце
that
порушення
had
правил
taken
дорожнього
place, the
руху.
violation of
Я
the
їх
traffic regulations,
сприйняв,
I had accepted them, I had recognized them, I had learned my lessons. As for the other circumstances, I had done the same. As for plagiarism, I don't feel that this was the case or had some elements of plagiarism. So on the position of the judge, if I'm given the opportunity to be a judge of the Hague Court, I believe I will be able to meet the high expectations put for the judge of the Supreme Specialized Court to administer justice, and no one will have doubts about my competence, my integrity, and professionalism. Thank you. Thank you, Mykhailo. I believe there are no further questions, so thank you for your participation. We wish you all the best. Colleagues, I'm announcing a recess to address a few procedural matters. Broadcast enabled 321. Colleagues,
Прийняти рішення спочатку
I
щодо
would urge you to make a decision
долучення документів, щодо
about
розгляду
the
клопотань, які були
admission
заявлені
of the
кандидатами,
documents
зокрема Боднаруком
as
Юрієм
requested by the
Володимировичем,
candidates,
Кімстачовим,
including
Олегом
Bodnaruk and
Сергійовичем.
Kimstanchov Oleg.
Пам'ятаєте, вони надали документи. Нам
They
потрібно
provided
прийняти
the
рішення про
documents, as you would
долучення
remember,
чи
so we need to decide whether to
відмовити
admit
долучення цих
them or
документів
decline their
до
request to admit the documents
досьє.
to the
Відповідно,
dossier,
якщо нема
to
заперечень, я
the
спрошу
case file. If there are no
ставлю це питання
objections,
на
I will
голосування,
raise the
щоб ми
question
одразу
for the
зараз
vote under the summary
проголосували.
procedure so that
Отже,
we can
хто за
put to
те,
vote.
щоб
So are you
долучити
for
документи,
admitting the
які подав
documents
Боднарук Юрій
submitted by
Володимирович
Yuri
до
Bodnaruk
матеріалів досьє?
to the case file?
Одноголосно, дякую, рішення прийнято. Хто за те, щоб
Thank
долучити
you. The
документи,
decision has
які
been
подав
made.
Кімстачов Олег Сергійович до
Who
досьє?
is for attaching the documents provided by Mr.
Одноголосно,
Kimstachov?
рішення прийнято.
Thank you.
Дякую.
The decision has been made.
Наразі прошу членів комісії та членів
I will ask the
громадської ради
members of the
міжнародних експертів
Commission
перейти до
and
закритого
the
обговорення.
PCIe to proceed to a closed discussion.